Do the Nijisanji contracts break the law? That's what we're going to go into right now, using actual Japanese penal code law, using the Japanese contract law that is actually out there in the code, codified in the system. We're going to take a look at whether Nijisanji is breaking the law with the employment contract that we've seen, and possibly any others that they are doing, because they need to follow their rules of employment that they have for employees, as these contracts show primarily that they are employees. I will be taking a look at everything, all the evidence that's in there, and I hope you guys enjoy. Here we have some things in regards to what happened recently in the Niji contract arguments, whatever you want to call it, that happened on Legal Mindset stream. This is, of course, taken directly from his stream. This is on the Nijisanji subreddit. This is just new information in regards to everything that's going on, the Japanese legal comments in the Nijisanji contract. And here we have it in a bit bigger statement here, so you guys can see it a little bit better. This is comments from those in the legal industry, as he's saying, and they're not his own comments. That is something that he wants to be known because he doesn't want it to be confused in any way. He says, contract clearly machine translated. As a native speaker, the document is clearly machine translated. Even from the title Business Entrustment Agreement, it directly translated. This is literally labeled as an independent contract agreement. So here we have the first problem. Now, someone from Japan who is a lawyer and is a native speaker in Japanese says that they most likely he says clearly, but they most likely machine translated what was going on here. What that means is that they took AI and told it, here's this, translate it please. They either used Google Translate or they used DeepL or whatever. It's like, translate this for me, and then they copy and paste it. The problem is, in Japan, from what I know, the language can be interpreted, like the words can be interpreted different ways depending on the machine language used, depending on what was being used at the time, all that kind of stuff. Yes, they're definitely using a lot of professionalism. They're definitely making sure that they are as professional as possible, because they're a large multi-billion-dollar corporation in Japan. Of course, they're going to have, people specifically, as a company would do. A good company would have someone to translate for them, a specific translator for especially legal documents. Like, what the heck is going on here? Especially for legal documents. Instead of saying independent contract agreement, they say business entrustment agreement, which is like, it's high schooler stuff, like has been mentioning. It's high schooler stuff. Article 12, Part 3 is unenforceable, according to this Japanese lawyer. Completely unenforceable under Japanese law because moral rights are codified as non-transferable under the Copyright Act of Japan. The contract itself stating transferred is a pretty big flag of incompetence. Ow. This sounds more to me like what they were trying to do is trying to make it in some way scare people with the moral rights. Scare people, especially in Japan, thinking, oh my God, they mentioned moral rights, which means that there's defamation, which means that there's a chance of defamation. There's a chance to a lot of things. And yes, as mentioned in the comments, yes, Japanese is a very context-based language. You cannot take it literally, which is what a lot of these machine learning things like Google and other ones, Google Translate takes a lot of the words and phrases in a literal sense and like a straight just as the word goes sense, and not in the context clues. So this is completely unenforceable according to what they're saying, because the moral rights are not transferable under the Copyright Act. And the contract stating that they're transferable is illegal. It's a pretty big flag, and it should never have been done by a competent lawyer. That's the main cue, a competent lawyer, which apparently the people that write these things for Nijisanji are not competent. Next, VTubers would not classify as independent contractors. Japan has 4 general employment categories. This matters a lot. This is the big crux of the issue. I have been saying, and a lot of other people have been saying, like Legal Mindset and others have been saying, they are not in any way independent contractors. Because employees are the ones that have to go through all these restrictions, have to go through training, have to go through all this stuff. You do that with an employee. You don't do that with any type of stuff like that. And that is the big crux of the issue here. It's just they want to treat you as contractors, but you're actually employees. But that won't happen. That won't be an issue unless you actually know how to fight it. A lot of these people don't know how to fight it. Temporary employees, independent contractors. However, in Japan, independent contractors typically may not be bound by an exclusivity clause. So if you are an independent contractor under Japanese law, according to this person, you would not be able to be told, no, you can't go to your past life account. You would not be able to be told, no, you can't go to this other agency. You would not be able to be told, like it says in the contract, that you cannot contract with third parties, you cannot do anything with third parties unless you get party A's permission. That is an employee part of it. As a independent contractor, I can go with whatever the heck I want. I can go to whoever the heck I want, according to this person in Japan. And that means that, like, if I wanted to go to Konami to do something with Konami, I could do that on my own. And all I would have to do is maybe pay royalties to Nijisanji for using their IP, if I use the IP there, or if I decide to go to my PL account and do it with Konami, I could do that. And Nijisanji wouldn't be able to do anything about it if I was actually an independent contractor, which, as stipulated here, most likely I wouldn't be if I was a VTuber under their contract. Continuing on, the many terms of this thing may be unlawful for employees in Japan. The potential violations are of the Labor Standards Act, the Penal Code, and the Protection of Personal Information Act. Because of the fact that they want, like, I remember there was a part in the contract where they say they want all of your information. This provision of information, they're saying that this one right here of getting all the information from the party, which is you, this, according to what we were reading before, is not something that, like, right here, according to what's being read here, the Protection of Personal Information Act would protect you against that Article 7 there, that Provision 7. The Labor Standards Act would protect you against almost every single provision that exists there. The Penal Code would probably also protect you for you know, other protections of, you know, enforceability after you're gone. The extreme restrictions that happen within the organization. There are a lot of things that companies like Nijisanji do when they feel they have the right to, when they feel that they have someone by the testiculars. In many cases, they think that, yes, they have the right to ask you all these things. They have the right to put all these things in there because it's not illegal until you get caught, is what a lot of people like Nijisanji seem to be thinking, and the Nijisanji lawyers seem to be putting into their specific contracts. It's like, it's not illegal if I don't get caught. It's not illegal if I don't get responsible for this. It's not illegal if the person that I am doing this to doesn't go and rat me out to the authorities, to the coppers, fellas. You know, if they don't go to the coppers, fellas, then nothing bad will happen. And of course, they won't get hurt by this. They won't get negatively affected by this. This is pretty crazy, honestly. It's pretty wild that a actual Japanese lawyer went through and mentioned all of these things. Mentioned that, of course, they are not they're not enforceable at all. They don't qualify as independent contractors just based on my independent contractor contracts that I've signed before. It does not fit what I've even signed here. And I'm glad that Japanese labor law actually has protections, and that this lawyer came out and actually mentioned the protections that Japanese labor law has for these types of things, that there are actual provisions to protect people like that. Article 9 of Japanese labor law states that an employer may not change any of the working conditions that constitute the contents of a labor contract in a manner disadvantageous to the worker by changing rules of employment unless an agreement to do so has been reached with the worker, provided, however, that this does not apply to the cases set forth in the following article. So they can't just unilaterally change things and say, because you did your work, you can be made responsible for it. Basically, you've accepted it. So you can't change the contents of the labor contract based on what you're feeling. It has to be based on the rules of employment, from what I'm getting here. And we have here the Labor Standards Act, which says, according to labor contracts, Article 13, any part of a labor contract that prescribes working conditions not meeting the standards of this act is void. In such a case, the part of the contract that is void is governed by the standards prescribed in this act. So basically, with a lot of the things, from what I'm understanding, with a lot of the things they wrote into the contract, the employee contract, it can be voided by this article here because it's prescribing working conditions that do not meet the Labor Standards Act of Japan. They don't meet even the standards that Japan, as a more free for, you know, corporate protections, even they say you can still be violated. Like, they can violate this act and it will be null and void. So they can even void it there. Exclusivity thing that they try to do, that would be more an employee thing, as I mentioned before, in regards to the things that I had read previously. And also, according to this, it also breaks the Labor Standards Act, which could make it something that is unenforceable. If you are a contractor, it would be unenforceable because, as the person that was a Japanese lawyer mentioned, it breaks the Labor Standards Act. It breaks a lot of labor code in Japan. You cannot make someone be a independent contractor and be exclusive to you. That just does not work even in Japan, which is interesting. According to the Labor Standards Act, the Japanese law, in Article 15, the fact that they try to limit, like the Japanese lawyer was saying, it's also illegal in this way, it's also legal in many ways. He mentioned many ways in the Labor Standards Act. One of the ways is that they have to be explicitly stating what your income is going to be. How much you're going to get paid per hour, how much you're going to get paid as a salary, how much you're going to get, the full breakdown of everything. It can't be like, oh, we're gonna give you a little bit of this, a little bit of that. You have to negotiate this, you have to negotiate that. If you're an employee, as they're pretty much putting it through, even as an independent contractor, from what I understand, correct me if I'm wrong in the comments and all that kind of stuff, but from what I understand, it's basically, if they are making things explicitly in here, the wages must be put, the particulars of wages and working hours must be put in there, and it must follow all the laws of the Order of Ministry of Health, Labor and Welfare. And if a working condition that has been made explicitly based on the provisions diverges from the facts of the matter, the worker may immediately cancel the labor contract. So if they change anything at any point in time, according to Japanese law, you can cancel that contract. You can just be like, nope, this is not what I signed up for. We're done. You can actually do that under Japanese law. In a case referred to by the preceding paragraph, if a worker who has changed residences for work returns home within 14 days after the date of contract cancellation, the employer must bear the necessity travel expenses. So if, for example, I was made to go to Japan to work, the contract was canceled at that moment, they have to pay the expenses of me going back to my home country, which is under Japanese law, but they don't have that in their contract. They don't do that. They say, they're only going to do it for certain situations, not for these. So that's another thing that has to happen. Also, there's prohibition for establishing the compensation of loss or damage in advance. An employer must not form a contract that prescribes a monetary penalty for breach of labor contract or establishes the amount of compensation for loss of damages in advance. So that whole 50% thing, that whole, they can take 50%, or they can take up to 100%, or they can take a penalty beyond the 100%. That is, from my understanding here, just from reading it and a layman's person, it is illegal under Japanese law. They cannot do that. So that is unenforceable even in Japan. Unenforceable / illegal, breaking the Labor Standards Act in Japan. That is, that whole penalty phase part, it is illegal in Japan. So that itself, they're screwing themselves over. So it isn't even enforceable in Japan. That's the crazy part. Basically, it protects against the rights. It protects the rights and interests of individuals while ensuring the smooth and proper management of the process of services administrative entities. So this is meant, this whole section, this whole protection of personal information, is to protect the actual information of the people who are employed by Japanese companies. So they cannot ask for your personal information. It breaks this specific act here, this large act. It can, make it so that it's also null and void. This is a secondary part of the not allowing, at least this Labor Standards Act of Japan doesn't allow penalties. In Article 91, it says, if the rules of employment provide for a pay cut as a sanction against the worker, the amount of the pay cut must not exceed half of 1 day's average wage per occasion. So they cannot do that 50% of anything that you've gotten. They cannot do that 100% of anything that you've gotten. They cannot do that penalty and 100%. So they can't do that, like I mentioned before. That is illegal. And the total amount of pay cuts must not exceed 10% of the total wages for a single pay period, for like the month or whatever. They can't do more than 10% of a single day's paid. And that is what they're breaking in that penalty part of the thing that we've seen before. This penalty phase, this whole thing is illegal under the Labor Standards Act right here. As a Japanese lawyer mentioned before, it's all illegal. This cannot be done because Article 91 says it. It can't be done. It basically states that you cannot make a penalty more than 10% of a total day's wage. And they're doing 50% of your total wages of the month, or 100% or 100% plus penalty. That is just not right. That can't be done under Japanese law. If a person knew their rights, which a lot of these people unfortunately do not know their rights, or just give them up in order to get the popularity and be part of a large company, they don't actually have a lawyer look at it, and they don't actually fight it. This is where they may have broken the law. Again, as a Japanese lawyer said, they may have broken the law in regards to a lot of other things that were going on. It says in Article 20, if an employer wishes to dismiss a worker, the employer must provide at least 30 days advance notice. An employer not giving 30 days advance notice must pay the worker the average wage they would earn in working for a period of at least 30 days. Provided, however, this does not apply if business's continuance has become impossible due to other compelling reasons. Basically, if they go bankrupt and they have to close, then they don't have to give the 30 days. But if they are a continuing organization that is continuing doing their stuff, they have to give 30 days notice, or if they don't want to, they have to give the person 30 days of actual pay for the period that they would have worked for those 30 days if they're going to terminate somebody. So terminating Selen Tatsuki, terminating Sayu the way that they did, they had to have given a 30-day notice before they did that. Anybody who's employed by them, that means contractors or employees. Number of days in advance notice set forth in preceding paragraph may be shortened by the employer pays the worker the average wage they would earn each day of work by which the advance notice period is shortened. So if they shortened it by 10 days, if they shortened it by 1 day, they have to pay 29 days. So that's what they have to do. Basically, they prorate it. It's prorated, pretty much. The provision of paragraph 2 in the preceding article may apply to mulatus in a case referred to proviso paragraph, and they do not apply if the person is a person hired on a day-to-day basis, which VTubers are not. If a person is employed for a fixed period no longer than 2 months, this may have been with the Sayu thing, because I think she had 2 months or less. A person employed in a seasonal work for a fixed period no longer than 4 months, this does not apply to VTubers. A person who is in a probationary period, this does not apply to VTubers unless they were suspended and then terminated. This is one way they can get around it. They can suspend somebody and then terminate somebody, and then they don't have to do the 30 days. Still, this is very shady. Finally, on the Sayu thing, another place where they might have broken the law, as a Japanese lawyer may have said, was that they could be considered as intimidation. The whole thing that was with the Sayu contract, the silencing contract, about, how they can give penalties if she puts this stuff out, all that kind of stuff. It says a person who intimidates someone else or is a threat, harm to life, body, freedom, reputation, a person's property is punished by an imprisonment of more than 2 years or 300,000 yen, which isn't even that much for a company. Same applies to a person who intimidates another person using a threat to harm life, body, etc. Or compulsion. Compulsion, I think, is where more this falls under. It doesn't fall under the first one. A person who intimidates another person using a threat to harm life, body, etc., which doesn't fall under this. Or reputation. Freedom or reputation of or property of another person by assault, etc. That doesn't fall under here. An act which the person had no obligation to perform, which was the act of being kind and the act of not releasing information, or hinders other person from exercising their own rights, is punished by imprisonment of not. Basically, the fact that they wanted her to not be able to exercise her own rights can be seen as intimidation. It's a stretch. It's a very long stretch, but I'm just showing possibilities. But it's a very long stretch with that one. On this one, same applies to a person who intimidates the reputation or property of the relatives of the person, which did not happen here, or cause a person to perform an act which the person has no obligation to perform, or hinders the person from exercising their rights. Any attempt to commit the crimes prescribed under this are illegal, and they can be punished. So if Sayu wanted to, they could try to get them on this penal code, on this crimes of intimidation, because trying to force her to do this and pretty much giving her a tacit thing saying that if you don't sign it, then there's possibility we could, badmouth you. It could be seen as intimidation from a large company. Now, like I said, that's a stretch. It's up to you to decide if it is or isn't. Once again, that was everything that we have so far. Everything that's codified into Japanese law. We do not know everything yet because we need to actually see the rules of employment that are a part of Nijisanji's thing. If there's more people that will be leaking this, we will see, and hopefully it will come out, and that will give us more news on that. Of course, comment down below if you so please. I do want you to also see if you can join my Discord or anything like that. My socials are in the description. Of course, enjoy the video that is on your screen. And like I said, any comments, commentary, criticisms, anything like that is always welcome. Enjoy your day. Have a wonderful time, everybody. Make sure to hydrate and eat well and rest well. Thank you so much. Bye-bye.